The verdict still being read out where the Chief Justice of India is concerned on the issue of Maharashtra. On the other hand, it's been a big win for Arvind Kejriwal. But let's get you the latest with what is coming in. I want to quickly pull in Nalini as well. Nalini, the Chief Justice of India, still reading out the verdict. Break it down, at least for what we are getting to understand till now. It seems to be advantage Uddhav faction.
Well, Preeti, let's remember the 2016 judgment that is being spoken about, the Nebam Rabia judgment, has essentially said that during the time when the notice for the removal of a speaker is pending, at that time the speaker cannot decide on the disqualification of any of the MLAs. Now, considering the fact that Eknath Shinde and his MLAs had approached the Supreme Court saying that we've already put in a notice for disqualification of the speaker and therefore he cannot decide on our disqualification, considering the fact that the Nebam Rabia judgment has now been referred to a larger 7-judge bench, it will be advantage Eknath Shinde as well as all of his MLAs, because that means that they will continue to be in power in Maharashtra. There will be no stepping down either for the Eknath Shinde himself as the Chief Minister or his MLAs who've taken oath in the government. At the same time, the Supreme Court, the matter continues to remain pending in the Supreme Court, because now a 7-judge bench will look into the aspect as to whether or not a speaker can even decide on disqualification proceedings at a time when his removal or notice for his removal itself is pending. Essentially, what the Supreme Court has done, because this was one of the first requests that were made before the Supreme Court in this matter, that this 2016 judgment directly impacts this case, and that's why a bench of the same strength as was there in the Nebam Rabia judgment cannot hear this case. It should go to a larger bench. But at that time, the Supreme Court has said that we are not going to decide on as to whether or not a larger bench should hear this without hearing the merits of the case itself. So now that the merits of the case have been made clear before the Supreme Court has decided that Nebam Rabia, that says that powers of a speaker, there is no power of the speaker to decide on disqualification if a notice for his removal is pending. That will now be considered by a 7-judge bench of the Supreme Court, and only the outcome of that is likely to impact as to whether or not there will be any change in the government in Maharashtra. For now, there is absolutely no change that has been ordered by
for now. Nalini, stay with me. Coming right back to you. I want to cut across back to Anisha. She's got more coming in on what is transpiring in terms of the Chief Justice of India still reading out the judgment. Over to you, Anisha.
Well, Paulami, this seems to be advantage of Uddhav faction right now in the Supreme Court as the Chief Justice is continuing to read out his verdict. He has said that the Speaker at the time when he called Mr. Shinde's, when he appointed the whip recommended by the Shinde faction, was aware of the fact that there was a split within the party and that the Speaker must only recognize whip appointed by the political party. It is a big verdict coming in from the Supreme Court. This is going to be and as we speak, Paulami, the verdict is currently going on. He is also now looking into the powers of the EC. At this moment, the question now before the court is also whether the Election Commission could have taken the kind of steps that it did, and the time that it would take for the power of the Speaker to attain finality is uncertain. The Election Commission of India is a constitutional institution entrusted with the function of the maintenance and control of the electoral procedure. Election Commission cannot be prevented from performing its constitutional duty for an indefinite period of time. But the court is still, as I say, it is still going on. They are saying that work of one constitutional authority cannot be halted due to something happening before another constitutional authority. It seems to be that the court is trying to It seems that the court is trying to draw a very, very delicate balance between what happened in Maharashtra and what happened within the Shiv Sena, where on one hand the court has said that the Speaker could not have appointed a whip without referring to the political party in question. He has also now saying that the Election Commission does have the power to decide on who actually has control of the political party on the basis of the party constitution and other factors. And as I say, Paulami, the court is trying to create a very, very delicate balance here. They are saying the court is now looking into the question of disqualification proceedings and whether the court I beg your pardon, whether the court can go into this matter at all. He is saying that the decision of the ECI cannot be relied on by the Speaker for adjudicating disqualification petitions if those petitions are already pending, because the decision of the ECI would then have a retrospective effect. So I clearly, Paulami, this is going to be a very, very complicated verdict, because on one hand, the court is saying that the Speaker could have taken a decision where, as far as the disqualification petitions are concerned, that the Speaker should have gone into an independent inquiry of who exactly is appointing the chief, the whip of the party in the assembly. But at the same time, it is also saying that the Election Commission could have done what it did. No faction or group can argue that they have a defense against disqualification on grounds of defection. It is a very, very important, very, very crucial point being made by the court, that what is exactly the anti-defection process, what happens when there is a disqualification process. These are extremely technical points being read out by the court, and we are here trying to interpret what the court is really saying here, because this is not something that will only have an impact on the Maharashtra politics. This is something that is going to have a huge impact on the politics of the country in general. And the Chief Justice, of course, is, as we speak, still reading out his verdict. He is going into the question of what happens when there are two whips appointed by two separate factions of the party. The Speaker has to decide on which of the two whips represents the political party on basis of an independent adjudication. That is something that the court has just said, and we are still listening to the court, that we are answering this question with regard to the whip. We have answered this question on the whip. Only the whip appointed by the political party can be recognized, because the Election Commission proceedings on the recognition of the party would be a retrospective exercise. The Speaker should have gone into the consideration at that point.
What went down, catch a breath, Anisha, catch a breath, coming right back to you. The Chief Justice of India still reading out the verdict. Trust us to get you one up on all developments. What happened in Maharashtra, viewers, was unprecedented. In terms of the judgment we are getting to here, highly complicated, but you're in the best channel for you to break it down for you, and that's what we are doing. I want to quickly pull in Nalini. Nalini, complicated, yes. Interimly, it does seem advantage Eknath Shinde camp because status quo remains. Having said that, it is also a blow to Eknath Shinde. So it's a delicate balance there, because when you read into the Supreme Court stating Maharashtra Assembly Speaker could not have recognized Eknath Shinde camp MLA as whip of Sena. So there's a lot of contours to this judgment being read out. Can you break it down for the layman of what we have heard till now?
Well, Preeti, first thing we need to understand is that there are a lot of finer constitutional aspects that the Supreme Court is ruling on, including what the powers of the Speaker are, what the powers of the Governor are, in fact, even what the powers of the Election Commission and the Supreme Court are of judicial review when it comes to matters like this, where there is a split between the political party. Now, keeping that in mind, there are certain aspects that are bound to go in favor of Uddhav Thackeray, and there are certain aspects that are bound to go in favor of Eknath Shinde. It depends how the pieces fall into place. At the same time, what the Supreme Court has said is that the appointment of the whip of the Eknath Shinde camp by the Maharashtra Assembly Speaker could not have been done, because only the whip appointed by the political party should be recognized. But at the same time, the Supreme Court is also speaking extensively about the powers of the Election Commission. Now remember, the Election Commission had recognized the Eknath Shinde camp as the real Shiv Sena, but what the Supreme Court is saying right now is that it was not necessary for the Election Commission to rely on tests regarding legislature alone. The Election Commission must look into other tests also while it's deciding as to whether or not a symbol should be granted to a political party. What the Supreme Court is also saying is that the disqualification proceedings before the Speaker cannot be stayed in anticipation of proceedings before the ECI, which means that the ECI proceedings regarding any split between a political party should have no impact on the proceedings that are ongoing before a house on aspects of things like disqualification or even removal of a speaker for that matter. What the Supreme Court also said is that if disqualification proceedings are decided based on the ECI decision, then it is bound to have a retrospective effect and it will be contrary to law. keeping in mind that they are both independent constitutional bodies, the decision of one should not impact the decision of the other. Especially, the decision of the Election Commission should not have an impact on the proceedings before the floor of the House. The third question that the Supreme Court has considered is as to whether or not both the factions can actually even claim to be the real Shiv Sena in this case. And what the Supreme Court said in regard to that is that no faction or a group can argue that they constitute the original party and that this is a defense for disqualification.
You know what's also interesting, and I'll bring in Anisha as well, but what's also interesting on the role of the governor, Mr. Koshari. The Supreme Court has said government had no objective material before him to believe that the incumbent government was not capable of running the government. Anisha. All right, we're going to cut across to Anisha and just about...
Yes, Preeti,
yes,
we are hearing we are keeping a constant eye. We are keeping a constant eye on what is happening in the court. I'm listening to the court as we speak. The court has very clearly said that a floor test cannot be used as a medium to resolve intra-party disputes. The governor must be cognizant of the constitutional norms. He should have taken into account what is happening. He cannot exercise a power that is not conferred upon him by the Constitution. The Constitution and the laws does not provide a mechanism by which a governor can look into disputes between the members of a political party. The governor was not empowered to enter the political arena. This is a big breaking news that I'm bringing to you. The court is reading out its order. The governor cannot act on an inference that he has drawn that a section of the Shiv Sena wishes to withdraw support from the government in the floor of the House. A floor test when it comes to the issue could not have been ordered by the governor. That is what the court seems to be saying at this moment. Preeti, what is the big takeaway from this section that is currently being read out by the court is that there is a presumption of legitimacy once there is an elected government, that the MLAs had not specifically said that they are withdrawing their support from the Maha Vikas Aghadi government. Nothing in the communication sent to the governor by the Eknath Shinde faction has at any point said that they intend to withdraw their support from the elected chief minister of the state. Very clearly, this seems to be advantage Uddhav right now.
You know, there are so many points there, Anisha. Catch your breath, go through what the court is saying, coming right back with you. Let's break it down. Nalini, pulling you in as well. You know, the contours of this judgment as complicated as what went down, which was unprecedented in Maharashtra, but interesting. When it comes down to the role of the speaker, when it has come down to the role of the governor, it seems to be advantage Uddhav Thackeray, the latest, also coming in, which the Supreme Court says, Nalini, no attempt by opposition party to issue no confidence motion against incumbent government. These MLAs were only a faction at most, indicated dissatisfaction.
Yes, Preeti, like I told you, there are going to be certain aspects that are going to be in favor of both sides, considering what a complex issue this is. But I believe what the Supreme Court has said is that the governor had no objective material before him to believe that the incumbent government, which was the Uddhav Thackeray government at that time, was not capable of running the government, and therefore to ask him to face the protest possibly was not done in the right manner. What the Supreme Court also said is that there was no attempt by the opposition party to issue a no confidence motion against the incumbent government, so the governor was not in a position to go ahead and ask for a floor test to happen. The Supreme Court has also gone ahead and said that once a government is democratically elected, there is always a presumption of legitimacy, which means that the democratically elected government should be allowed to function unless and until there is an objective material to show that they are not able to function legislatively. So keeping that in mind, the Supreme Court said
there's more coming in, Nalini. On the role of the governor, there's more coming in. Anisha, I'm going to cut across to you. I'm sorry I cut you short, Nalini, but important updates coming in from the court, Anisha, where the Supreme Court has said Constitution authority derives power from Constitution. Governor cannot exercise power not available under the Constitution.
Well, Preeti, as we've been discussing, it is a very complicated, very nuanced judgment that is coming on from the court. What the Chief Justice is saying, that the governor ought not to have relied on the letter sent by the Shinde faction on the 22nd of June. There was nothing in that letter to show that the Uddhav Thackeray had lost the confidence of the House. The governor could not have considered the security concerns raised by the MLAs who had sent in the letter, that they are facing threat to life and their property and their families. That was not enough for the governor to take a decision. Importantly, and Preeti, this is something that the Chief Justice is just saying, Devendra Fadnavis and the other MLAs could have moved a no confidence motion themselves. That there must, for the governor to take a decision unilaterally was incorrect. The governor did not have any objective material before him to indicate that the Uddhav government had lost the confidence of the House and that he should be calling a floor test. That the discretion of the governor was not in accordance with the law. A big point being made by the Supreme Court here. And now, of course, as we speak, Preeti, the Chief Justice is still reading out his verdict.
Hear it out, Anisha. Coming right back to you. Hear it in. Encapsulate your points. Like I said, it's a complicated judgment, but it was a complicated case on what went down in Maharashtra. Unprecedented, never had happened in Indian political history. Nalini, I'm going to bring you in, because at least, with what we are hearing in from the Chief Justice of India right now, he's practically taken up the role of Mr. Koshyari, the governor at that point of time.
Yes, Preeti, and this was one of the arguments that was made by the Uddhav Thackeray faction while the arguments were going on before the Supreme Court. They had questioned the order that was issued by the governor. They had specifically criticized his role in this entire crisis that had accrued in Maharashtra, and they had said that he was not entitled to make these political decisions in the first place. And that's precisely why even the Supreme Court, regarding the role of the governor, has gone ahead and said that the governor is not entitled to enter the political arena and play a role in an intra-party to inter-party dispute. He cannot act on the basis that some members want to leave the Shiv Sena, and the governor cannot...
More so coming in, very interesting. I'm sorry I'm coming in, but more so coming in, and it's very, very interesting because the latest is that the court says, had Uddhav Thackeray not resigned, the court could have given relief. Trust vote was not held.
Yeah. Yes, Preeti, that's the latest coming in from the Supreme Court. Where the Supreme Court said, and it's CJI Chandrachud who's reading out the verdict, he said that had Uddhav Thackeray not resigned, this court could have given relief. Remember, instead of facing the floor test, Uddhav Thackeray had put in his resignation after the order from the governor had come in this aspect, and that was the time when the matter was still going on before the Supreme Court. The Uddhav Thackeray faction had approached the Supreme Court trying to get a stay on the floor test, but at that time no stay was granted. But one thing that the Supreme Court had said is that anything that happens in Maharashtra will be subject to the final outcome of the Supreme Court, which is what is being pronounced today. So whatever is decided today by the top court is what is going to determine the future of the government in Maharashtra. And what the Supreme Court has said is that there was a possibility of Uddhav Thackeray getting relief if he had not resigned as the Chief Minister and had gone ahead and conducted the trust vote first. At the same time, they are also saying that the governor in this entire aspect should not have entered the political arena, and without any objective material before the governor, they should have not asked Uddhav Thackeray to face the floor test, because there was no reason provided as to why the government could not...
I want to ask you, Nalini, I want to ask you from a layman term. The Supreme Court saying Devendra Fadnavis, independent MLAs, didn't move a no-confidence motion. Governor exercise of discretion was not in accordance with the law. The role of the Speaker. Is the Supreme Court indicating that the Maharashtra's current government is illegal?
Preeti, we will not go so far as to speculate that, but let me tell you what the Supreme Court is saying. The Supreme Court is saying that this is an intra-party dispute. There were some MLAs within the Shiv Sena that were not happy, that wanted to break away from the party, and there was a rift between different factions of the same party. But at the same time, this was not enough for the governor to go ahead and call the government's functioning as not a possibility. There was no objective material before him to go ahead and say that the government is not going to be able to function properly and force Uddhav Thackeray at that point to face the floor test. So that is essentially what the Supreme Court said.
It's very interesting. Nalini, it's very interesting because the latest that's also coming in, and Anisha, I'll bring you in. Because the court has said, had Uddhav Thackeray refrained from resigning, this court could have reinstated him. But the court cannot quash a resignation. This is huge. Anisha, can you hear me?
Preeti, this is a very, very delicate balance that the court has made. If you can hear me.
Yes, go ahead.
Preeti, can you hear me? Hello? Yes, if you can hear me, Preeti, this is a big moral victory right now for Uddhav Thackeray. But since he had resigned, the court has very clearly said, we cannot restore you to the government because you chose to resign. However, politically and legally, the court has given a huge amount of ammunition to the Thackeray faction right now by saying that the governor as well as the speaker acted outside of their purview. They could not, the speaker could not have recognized a whip which was not from the political party, but the status quo ante cannot be restored because the governor called the leader of the largest party in the house, and Eknath Shinde had been recognized at that time by the trust vote as the leader of the house. So after a huge moral victory for the Uddhav faction, legally and politically, Eknath Shinde government will continue in Maharashtra, because even as the court has said that the governor and the speaker as well as Devendra Fadnavis and his supporters acted outside of their purview, but with Uddhav Thackeray's resignation, Eknath Shinde was recognized by the house as the leader of the house, and that is why the governor was justified in inviting him to form the government. A big moral victory right there for Uddhav Thackeray, that what happened was not correct, but at the same time, because he himself resigned, he does not get a win, he does not get back the government of Maharashtra. Very clearly, Preeti, this verdict is going to be something that will set out the future of politics in the country. It will set out how a split in the party is considered going forward. But for today, for Maharashtra, this is something that Uddhav Thackeray has lost out on. Back to you.
Well, interesting. We are breaking it down, viewers. So, what it seems to suggest with all the points that are coming in from the Supreme Court as of now, seems to suggest that it's a big moral victory, which Anisha said, when it comes down to the Uddhav Thackeray faction. But that's what it is, because the incumbent government stays. Primarily, Nalini, I'm going to pull you in on this, stating that had Uddhav Thackeray, and that's the key, had Uddhav Thackeray not resigned, the court would have reinstated him. However, he did not take a floor test. The governor was correct then, calling upon the Eknath faction to form government. Interesting what's going down. One can understand that the Uddhav Thackeray faction will make a political meal of it when it comes down to, the moral victory angle. But on the other hand, the incumbent government stays.
Well, yes, Preeti, and I believe what the Supreme Court is saying at this point is that the governor had only simply relied on a letter that was given by Devendra Fadnavis along with 7 MLAs. And what these MLAs could have done instead of going to the governor was actually move a motion of no confidence before the assembly itself. Nothing stopped them from doing that, but they did not do that. They went to the governor. So the Supreme Court has actually criticized the actions of the governor, saying that there was no objective material before the governor to call for a floor test, and his decision for calling for a floor test was actually not in terms of law. That is what the Supreme Court said, criticizing the decision of the governor. But in the same breath, they have gone on to say that had Uddhav Thackeray not resigned, this court could have given him relief. The trust vote was not held. Both the Speaker and the Election Commission are well empowered to concurrently adjudicate on this aspect, but the governor at the same time was not justified in calling Uddhav Thackeray to prove the majority before the House. So there is a problem on both sides, where on one side the order of the governor calling for the floor test should not have been passed because there was no objective material, and the MLA should have moved before the assembly with a no confidence motion instead of going to the governor instead. But on the other side, Uddhav Thackeray should have faced the trust vote, is what the Supreme Court is saying. Uddhav Thackeray today would have been in a far better position. He could have hoped for some relief from the Supreme Court in case he had faced the trust vote, which he did not do, and instead he went on and resigned as the Chief Minister of Maharashtra. which means that the Supreme Court is saying that the governor was not justified in calling Thackeray to prove the majority, and that the status quo cannot be restored right now as Thackeray did not take the floor test. So that's a big setback coming in for Uddhav Thackeray, where the Supreme Court has not only ruled against him and his faction, but they've also pinned the blame on him for making sure that there is no relief coming in from the top court, because he did not face the floor test in the very first place. And in case he'd done that, instead of resigning, the Supreme Court could have tried to offer him some relief in these final constitutional aspects. The governor was not justified in calling for a floor test, but because of the fact
that stay with me, would you just stay with me? Let's just break it down. I want to quickly cut across. Priyanka Chaturvedi is joining us on the phone line from UBT, the Uddhav faction. Priyanka Chaturvedi, you can go back home with a moral victory, but the sheer fact of what you wanted relief, that hasn't come. And the blame is on you. You should not have quit. If you faced the floor test, possibly it would have been different today.
No, I am really sorry. You've misunderstood the judgment. If he has called the disqualification, the appointment of the whip as an illegal act, the governor's act of calling for a floor test, which is unconstitutional, illegal, going beyond his authority. It's not just a moral victory. It's a victory of India's constitution. Now, it is now in the domain of the Speaker of the House to ensure that those whose disqualification we seek is heard by him, by the chief whip appointed by us, which is Sunil Prabhu. And I do not think that the decision on this particular instance of not ensuring the status quo ante was something that we were really fighting for. What we were fighting for was the illegality of everything the governor was doing, illegality of the decision of conducting a floor test, illegality of these MLAs appointing a chief whip and leader of the House. And that has been upheld by the Supreme Court.
But Priyanka Chaturvedi, the fact is, yes, that has been upheld by the Supreme Court in terms of, what the Supreme Court has said on the role of the governor practically taking him apart, the role of the speaker. But in the end of the day, what is it that you had hoped to achieve from the top court of the country? Because the current incumbent government stays, Ms. Chaturvedi. And the blame is on you. If you had faced the floor test, it would have been a different outcome possibly.
No, even if the entire consequences of conducting a floor test, the immoral way the floor test was conducted by appointment of an illegal whip, that in itself shows that they have lost the moral authority to govern. Now, it is for the people of the state to understand, and that is exactly what the Chief Justice has said, that these are people appointed under the party symbol. And in fact, he has also told the Election Commission the decision that they have taken cannot be only on the basis of the legislative strength of those who have defected. So those are huge judgments coming in our favor, which will go in a long way to ensure that this kind of bending of constitutional authority and bypassing the 10th schedule, bypassing the anti-defection law, cannot function in India's democracy.
Ms. Chaturvedi,
I look at it as a huge win.
All right. You look at it as a win, I'm just going to cut across to Sanjay Raut from your own party speaking right now. Listen in.
कोर्ट का अगर आप निर्णय देखें तो हम खुश हैं कि देश में लोकतंत्र और न्याय व्यवस्था आज भी जिंदा है। संविधान मरा नहीं है या कोई संविधान की हत्या नहीं कर सकता। सत्ता आती है, सत्ता चली जाती है। सबसे पहले जो सुप्रीम कोर्ट ने कहा है कि जो शिंदे गुट का व्हीप है वही गैर कानूनी इलीगल है। उसका मतलब है वो लोगों ने जो व्हीप बजाया था वो गैर कानूनी है और हमारा जो व्हीप था उसने जो आदेश दिया है वो कानूनी है। वो उस व्हीप के मुताबिक तो सब लोग अभी डिस्क्वालीफाई हो जाएंगे। विधानसभा अध्यक्ष को अधिकार है, ठीक है, लेकिन लीगल व्हीप कौन है? प्रभु है। ये सर्वोच्च न्यायालय ने कहा है। तो क्या विधानसभा के अध्यक्ष गैर कानूनी काम करेंगे? क्या संविधान की हत्या करेंगे? नहीं, पण एखादी मुदत बरोबर आहे। लवकरात सर्वोच्च न्यायालयाच्या सगळ्या घडामोडींवर लक्ष आहे आणि विधानसभेचे अध्यक्ष या डॉक्टर आंबेडकरांच्या महाराष्ट्रामध्ये संविधानाची हत्या करू शकत नाही। नैतिकतेच्या मुद्द्यावर ताबडतोब मुख्यमंत्र्यांनी आणि त्यांच्या सरकारने राजीनामा द्यायला पाहिजे। उगा टाळ्या वाजवत बसू नये। राज्यपालांची प्रत्येक भूमिका बेकायदेशीर आहे।
सर, आपने जो पॉइंट रखा है सरकार आता तरी कायम असल्याचं
अरे सोडा हो, कायम बेम कसलं आहे, गेलं ते सरकार।
राउत, आपने जो पॉइंट रखा है उद्धव ठाकरे अगर रिजाइन नहीं देते तो
ये बात सही है। कानूनन मुद्दा है कि उसका ही मतलब है अभी की सरकार गैर कानूनी है। अगर सुप्रीम कोर्ट ये कहते हैं कि अगर उद्धव जी ने नैतिकता के आधार पर रिजाइन किया है, इस्तीफा नहीं देते, तो आज हम उस स्थिति में होते कि उद्धव ठाकरे जी को मुख्यमंत्री के तौर पर फिर एक बार स्थापित करते। उसका मतलब है जिस तरह से सरकार नई सरकार बनाई ये पूरी तरह से गैर कानूनी है और संविधान के खिलाफ बनी है। दूसरी बात सर्वोच्च न्यायालय ने जो कहा है कि शिवसेना किसी गुट की नहीं हो सकती, ओरिजिनल पार्टी है, उनके पास रहेगी। मैं मानता हूं, मैं सर्वोच्च न्यायालय का आभारी हूं।
All right, Sanjay Rao there saying that this government is illegal. But what is really interesting, viewers, and I want to bring in our two crack legal reporters on this, because what the Supreme Court has done today is, if you look at the contours of this judgment, very interesting. Because what the Chief Justice of India read out practically stated that everything leading up to the instatement of Eknath Shinde as the Chief Minister was illegal, but the government states. Let's listen in to all the reactions that are coming in.
The court has clarified that had Mr. Thackeray would not have resigned, then in that scenario, status quo ante would have been granted. But now, since he had resigned himself, therefore court can't do anything.
The court also basically stated if Uddhav, after Uddhav resigned, then it was absolutely legal to call in for a protest by the governor.
That I could not hear. Once the judgment is out, we'll clarify.
Just to clarify, what has the court said regarding the role of the governor?
It said that the governor should not have taken into account because there was no objective material on the record.
So effectively what the Shinde faction MLA said was not objective material to topple the government, but because the government resigned by itself, therefore they will not get any relief.
That's what I can understand. When the judgment is out, we'll clarify.
With regards to the whip, the Supreme Court had certain observations.
So on the issue of whip, yes. So on the issue of whip,
that was
I'll answer this question first. On the issue of whip, the court has said that the whip of the political party will be given primary consideration.
But at this point of time, then who will be the new whip will be the
political leaders.
Abhikal.
आप किसके तरफ से तय कर रहे हैं? There are also senior advocates and political leaders coming out now.
All right, so once again, viewers, let me break it down for those who are joining us. Yes, it's a huge moral victory when it comes down to the Uddhav faction. But ultimately, what has transpired? No relief for the Uddhav faction. Eknath Shinde remains as the Chief Minister of Maharashtra. To break it down further, the Chief Justice of India, practically on the role of the governor, on the role of the speaker, on Mr. Devendra Fadnavis, on whatever his observations were leading up to the judgment, was very clear that if you try and interpret it, everything leading up to the instatement of Mr. Eknath Shinde as Chief Minister seemed to suggest was illegal by what the top court said. But Eknath Shinde still remains as the Chief Minister because Mr. Uddhav Thackeray chose to resign and did not face a flaws test. The court said very clearly that had Mr. Thackeray not resigned, then he could have been reinstated by the top court, but now nothing can be done.
इलेक्शन कमिशन ने माननीय मुख्यमंत्री एकनाथ शिंदे साहेबांकडे दिलेले आहे, त्यामुळे तो पण मुद्दा आता क्लिअर झालेला आहे. त्यामुळे आता पॉलिटिकल पार्टी इलेक्शन कमिशनच्या जी प्रोसिजर आहे त्या संदर्भात पण माननीय न्यायालयाने टिप्पणी केलेली आहे. तर ती त्या संदर्भात नंतर क्लिअरिटी येईल. परंतु इलेक्शन कमिशनने आता माननीय मुख्यमंत्री एकनाथ शिंदे साहेबांकडे शिवसेनेची धुरा दिलेली आहे. त्यामुळे पॉलिटिकल पार्टीचे संपूर्ण अधिकार एकनाथ शिंदे साहेबांकडे आहे आणि त्यामुळे पॉलिटिकल पार्टीचा व्हीप हा ग्राह्य दिला जाईल.
निवडणूक आयोग घेऊ शकतो असं पण सांगितलं आहे की निर्णय त्याचा निवडणूक आयोग देऊ शकतो.
हा निवडणूक आयोग पूर्ण निर्णय देऊ शकतो. निवडणूक आयोगाने ऑलरेडी निर्णय दिलेला आहे. त्यामुळे निवडणूक आयोगाने जो निर्णय दिलेला आहे की पॉलिटिकल पार्टी एकनाथ शिंदे साहेबांकडे आहे, तर त्यामुळे हे तीन निर्णय अत्यंत महत्त्वाचे आहे की सरकार हे गोगावलेंची नियुक्ती बेकायदेशीर ठरली नाही, ती प्रोसिजरच्या संदर्भात त्यांनी उल्लेख केलेला आहे. पॉलिटिकल पार्टीने त्याचा नियुक्ती करायला पाहिजे आणि आता इलेक्शन कमिशनने पॉलिटिकल पार्टीचे अधिकार माननीय एकनाथ शिंदे साहेबांकडे दिल्या कारणामुळे पॉलिटिकल पार्टी आता एकनाथ शिंदे साहेबांच्या आणि एकनाथ शिंदे साहेबांनी नियुक्त केलेला व्हीप भरत शेठ गोगावले आहेत, त्यामुळे तो अधिकृत व्हीप आहे. याचा निर्णय आता स्पीकर घेतील, कारण पॉलिटिकल पार्टी नाही बरोबर. राज्यपालांच्या भूमिकेच्या संदर्भात पण माननीय न्यायालयाने टिप्पणी केलेली आहे, परंतु माननीय न्यायालय या संदर्भात आपली भूमिका स्पष्ट केलेली आहे. परंतु आता क्लॅरिटी झालेली आहे, या सरकारला कुठला धोका नाही. अपात्रतेच्या संदर्भात पण निर्णय आता स्पीकर घेतील. आज बड़ी राहत है. माननीय सर्वोच्च न्यायालय ने जो निर्णय लिया है वो निर्णय का हम लोग स्वागत करते हैं. जो नाबाम रेबिया का रेफरेंस दिया था उसमें 179 और 180 में कुछ अमेंडमेंट करने की जरूरत है, तो वो लार्जर बेंच के पास उन्होंने रेफर किया, क्योंकि कॉन्स्टिट्यूशन में अगर चेंजेस करना है तो लार्जर बेंच के पास वो जाना चाहिए, ऐसा सुप्रीम कोर्ट ने कहा हुआ है. और जो अपात्र के गवर्नर के बारे में भी माननीय सर्वोच्च न्यायालय ने जो टिप्पणी की है उसके बारे में उनकी जो प्रोसीजर है, प्रोसीजर फॉलो करने के बारे में. लेकिन अभी जो व्हीप अपॉइंट किया हुआ है वो पॉलिटिकल पार्टी व्हीप अपॉइंट कर सकती है. और इलेक्शन कमीशन के निर्णय
comments made on election commission, but election commission already given its order on who the real Sena is. There have been comments made on the appointment
जो हमारे व्हीप है वो ऑफिशियली है, उसका निर्णय अभी स्पीकर लेंगे. माननीय न्यायालय ने ये भी कहा कि जो भी अपॉइंटमेंट है वो पॉलिटिकल पार्टी के थ्रू होनी चाहिए. तो अभी इलेक्शन कमीशन का जो डिसीजन है वो बहुत ही इंपॉर्टेंट है कि उन्होंने पॉलिटिकल पार्टी के पूरे राइट्स एकनाथ शिंदे साहब के पास देने की वजह से तो पॉलिटिकल पार्टी की जो अपॉइंटमेंट है वो सब ऑफिशियली अभी इसका निर्णय पूरा स्पीकर साहब लेंगे. और विद इन उनको एक टाइम लिमिट जो है,
सरकार को बहुत बड़ा रिलीफ है.
बहुत बड़ा रिलीफ है, क्योंकि बहुत महाराष्ट्र के जो पॉलिटिकल जो एटमॉस्फेयर था बहुत ही खराब था, जो अनस्टेबल था पूरा. और अभी एक स्टेबल गवर्नमेंट मिलेगी, स्टेबल एटमॉस्फेयर हो जाएगा और पॉलिटिकल सिचुएशन पूरी स्टेबल हो जाएगी. मैं माननीय न्यायालय का जो भी निर्णय है उसका स्वागत करता हूँ.
राहुल जी सवाल एक ये है कि कोर्ट ने ये भी कहा कि अगर उद्धव ठाकरे रिजाइन नहीं करते तो रिइंस्टेट करने की बात होती है. और जो अब शिंदे सरकार के लिए जो उनका रिइंस्टेटमेंट था, जो उनको सीएम बनाया गया, उसको कम्प्लीटली एक तरह से इलीगल कहा है. सरकार ने कहा है कि वो लीगल है, लेकिन ये कहा है कि अगर उद्धव ठाकरे रिजाइन नहीं करते तो रिइंस्टेट करने की बात होती है.
त्या मुद्द्यांवरती बरीचशी क्लिअरिटी आज आलेली आहे. आज सुप्रीम कोर्टाने शिंदे सरकारला, राज्यपालांना ज्या पद्धतीने फटकारलंय ते एक एक मुद्दे मी आपल्याला सांगतो. हे पिटिशन परत अध्यक्षांकडे पाठवण्यात आलेलं आहे. हे पिटिशन डिसाईड करताना अध्यक्षांनी व्हीप कुठला असावा हे ठरवायचं आहे. आणि हे ठरवताना आज सुप्रीम कोर्टाने अतिशय स्पष्ट सांगितलेलं आहे की व्हीप हा पॉलिटिकल पार्टीने नेमलेलाच व्हीप असायला पाहिजे. त्यावेळेचा जो व्हीप होता हे सुनील प्रभू होते, त्यामुळे सुनील प्रभूंनी दिलेले आदेश हेच ह्या पिटिशनमध्ये अंतिम ठरणार आहेत, हे आज अतिशय स्पष्ट झालंय. तिसरी गोष्ट, राज्यपालांनी जे अधिवेशनाच्या संदर्भात फ्लोर टेस्टचे जे आदेश दिले होते,
What was said in the context of floor test?
कारण सबळ पुराव्याच्या अभावी, सबळ डॉक्युमेंट्सच्या अभावी अशा प्रकारे राज्यपालांना फ्लोर टेस्ट बोलवता येत नाही. केवळ काही आमदारांनी पत्र दिलं म्हणून फ्लोर टेस्ट बोलवता येत नाही.
Governor shouldn't have called for a floor test just on the basis of some letters from some MLAs.
त्याची पडताळणी करून फ्लोर टेस्ट असेल किंवा अधिवेशन बोलवण्याचं काम केलं पाहिजे. मला वाटतं भारताच्या इतिहासामध्ये राज्यपालांना अशा पद्धतीने पहिल्यांदाच फटकारलं गेलं आहे.
For the first time in Maharashtra's history has a governor been in fact reprimanded in such a manner.
नबम रबिया केस आहे, ही 7 बेंचच्या समोर गेलेली आहे. त्यामुळे अध्यक्षांचे अधिकार हा एक वेगळा विषय झाला. पण जरी आताच्या अध्यक्षांच्या समोर जाईल त्याच्यामध्ये सुनील प्रभू हेच व्हीप असतील आणि सुनील प्रभूने दिलेले आदेश हेच मान्य करावे लागतील. त्यामुळे ही क्लिअर कट अशी गोष्ट स्पष्ट झालेली आहे की सुनील प्रभूंचे आदेश ज्यांनी मानले नाहीत ते डिस्क्वालिफिकेशनला पात्रता ठरतात.
It's become clear that whoever did not listen to Sunil Prabhu, they are in fact
जे 3
to face disqualification.
प्रोटेक्शनचे आहे त्याच्या बाबतीत देखील सुप्रीम कोर्टाने सांगितलेलं आहे की मर्जरचा जो पर्याय आहे हाच फायनल आहे. त्याच्या बाबतीमध्ये देखील राज्यपालांनी योग्य तो सभा अध्यक्षांनी योग्य तो निर्णय घ्यावा. त्यामुळे
Supreme Court has also said that merger is the only alternative.
हे अतिशय स्पष्ट झालं आहे की हे 16 आमदार डिस्क्वालिफिकेशन पासून वाचू शकत नाही.
It's become clear that these 16 MLAs can't escape disqualification.
29 आमदारांचं पिटिशन आमचं जे अध्यक्षांकडे पेंडिंग आहे ते देखील रिझनेबल टाइम मध्ये घेतलं पाहिजे.
A decision has to be taken on our petition, which is before the governor.
आम्ही ताबडतोब सुप्रीम कोर्टात येऊ. पण आजच्या निर्णयाचा फटका हा शिंदे सरकारला बसलेला आहे आणि त्यामुळे आम्ही
has been a scathing slap on the Shinde Sarkar's face.
असेल तर शिंदे सरकारने ताबडतोब राजीनामा दिला पाहिजे.
Shinde government should step down immediately.
रिझनेबल टाइम हा एका केसमध्ये मणिपूरच्या ठरलेला आहे. 3 महिन्याचा रिझनेबल टाइम आहे.
There is 3 months reasonable time.
सुप्रीम कोर्टाच्या आदेशाची प्रत मिळताच आम्ही अध्यक्षांकडे अप्रोच होऊ. त्याचं कारण असं आहे की तो फुलपेज ह्याच्यामध्ये आदेश दिला होता. आम्ही 10 ते 15 दिवसातच हे पिटिशन ऐकून घ्यावं कारण याच्यामध्ये व्हीप अतिशय स्पष्ट झालेला आहे की व्हीप सुनील प्रभूच असणार आहे.
It's become clear that the whip will be Sunil Prabhu.
बाबतीमध्ये व्हायोलेशन झालंय हे ऑलरेडी रेकॉर्डवरती आलेलं आहे.
Now there has been a violation and that's on record.
याच्यामध्ये पुरावे तपासायची गरज नाही कारण सगळ्यांनी हात वर करून त्यांच्या व्हीपचं व्हायोलेशन केलेलं आहे. तोंडी व्हायोलेशन केलेलं आहे.
Everyone who in fact raised their hands during the floor test have violated the whip.
मध्ये जास्त वेळ लागणार नाही कारण सगळे पुरावे विधानसभेच्या रेकॉर्डवरती आहेत.
All
तपासायचे
the evidence is before the Vidhan Sabha and it's on its record.
सायन्स रॉकेट सायन्स नाहीये.
This is no rocket science.
10 ते 15 दिवसामध्ये हे सरकार जाईल असा आमचा
In 10 to 15 days this government will go.
राहुल शेवाळे काय म्हणतात याला मी जास्त महत्व देत नाही.
I don't give much importance to what Rahul Shewale says.
मी याला जास्त महत्व देतो. आज सुप्रीम कोर्टच्या जजेसने जे सांगितलेलं आहे तेच मी आपल्या समोर सांगतोय.
I give more importance to what the Supreme Court says. I'm saying to you what the Supreme Court has said.
राहुल शेवाळे काय म्हणतात याला मी फार महत्व देत नाही. माझं म्हणणं असे सुप्रीम कोर्टाने आज काय म्हटलंय हे जास्त महत्वाचं आहे. त्याच्यामुळे त्यांना दिलासा आहे फक्त 15 दिवसाचा.
They might have got some relief, but it is only going to last 15 days.
नक्कीच आम्ही असं नाहीये. उद्धव ठाकरेंनी राजीनामा त्यांनी एकच मुद्दा सांगितला. उद्धव ठाकरेंनी राजीनामा दिल्यामुळे आम्ही स्टेटस को देऊ शकत नाही. म्हणजे याचा अर्थ तुम्ही नीट समजून घ्या की याचा अर्थ त्यांची ऍक्टिव्हिटी इल्लीगल झालेली आहे हे जवळपास कोर्टाने मान्य केलंय.
The court has admitted that their activity was illegal when they say that because Uddhav Thackeray resigned, we couldn't give any relief, but they've admitted to the illegality of what happened beforehand.
की हे ऍक्टिव्हिटी इल्लीगल झालेली आहे. आम्ही आता जजमेंटची कॉपी हातात आल्यावरती ती घेऊन अध्यक्षांच्या समोर जाऊ.
We'll go to our party president with the judgment order copy.
याच्यामध्ये वेळ काढण्यासारखी परिस्थिती नाही. सगळे पुरावे उपलब्ध आहेत.
We have all the evidences and proofs.
रेकॉर्डवरती आहेत.
It's all on record.
तपासून निर्णय द्यायचा आहे आणि व्हीप एकदा फायनल झालेला आहे.
When the whip is final,
त्याच्यामुळे आता परत याची चौकशी करत बसण्याची किंवा याच्यावरती कुठलाही अजून डोकं लावून नवीन जजमेंट्स वाचायची गरज नाही.
there's no need to look at anything new.
लेकिन एक बात है कि यहाँ पे जो लोगों के मन की सरकार थी वो सरकार सुप्रीम कोर्ट ने उसको यहाँ पे बचाया है. निश्चित तौर पर विकास के लिए ये सरकार का यहाँ पे रहना बहुत जरूरी था. मैं ये सुप्रीम कोर्ट के निर्णय का स्वागत करता हूँ.
लेकिन जो उद्धव ठाकरे गुट है वो तो सीधा हमला कर रहा है कपिल साहब. उनका ये सीधा आरोप है कि स्पीकर ने गलत फैसला लिया भरत गोगावले को व्हिप अपॉइंट करके. राज्यपाल ने गलत फैसला लिया. तो फिर नैतिकता पर आप लोग कहां टिकते हैं?
ये तो सुप्रीम कोर्ट ने जो दिया है आज इसका मैंने वही कहा कि अभी इसके ऊपर जो विधानसभा का अध्यक्ष जो है वही निर्णय जो सुप्रीम कोर्ट का आया है इसका स्टडी करके वही कुछ बता सकेंगे। उसके निर्णय के ऊपर मैं कुछ टिप्पणी करूं तो मैं तो उसके लिए सक्षम नहीं हूं, और राज्यपाल के निर्णय के ऊपर भी मैं क्या टिप्पणी कर सकता हूं।
नहीं, लेकिन जो शिवसेना के जो उद्धव गुट कह रहा है उस पर तो टिप्पणी कर सकते हैं ना। वो कह रहे हैं कि आप लोग का मॉरल स्टैंडिंग है। जी जी बोले कपिल साहब।
पहले दिन से कह रहे थे कि ये सरकार असंवैधानिक है, वो तो सुप्रीम कोर्ट ने उनकी बात खारिज कर दी, उसके ऊपर वो कुछ टिप्पणी नहीं करेंगे, वो तो अपना ही चलाएंगे। अभी वो अपोजिशन में चले गए हैं तो वो तो अपनी बात ही कहेंगे।
तो आप लोग जश्न मनाएंगे कि अब तो आप लोगों की सरकार बरकरार रहेगी, लेकिन वो लोग हमला तो और तेज करेंगे ना। अब 24 तक, 24 में से हथियार के तौर पर इस्तेमाल किया जाएगा ना।
देखो ऐसा है, अभी 2024 का चुनाव है, 1 साल उसको इंतजार करना पड़ेगा। उस वक्त कोई कौन सा हथियार यूज करता है, उसके बाद और कोई हथियार यूटी के पास भी आ जाएगा। ऐसा उस वक्त किसने देखा है 2024 का। भी हमारा मुद्दा तो, हम तो चुनाव में विकास के मुद्दे पे जाने वाले हैं।
Let's cut across to Mr. Girish Mahajan. He's Minister of Medical Education, Maharashtra, from the BJP. Mr. Mahajan, appreciate you joining me. You know, sir, today you can say that yes, the Supreme Court ultimately has reinstated or had shown faith that the continuance of the Eknath Shinde government. But the moral victory today clearly goes to Uddhav Thackeray, where the Supreme Court elucidated very clearly, sir, that what can be interpreted, that everything that went into instatement of Eknath Shinde as the Chief Minister was illegal.
हेलो, आज एक बहुत महत्वपूर्ण निर्णय माननीय सर्वोच्च न्यायालय ने दिया है जिसका इंतजार पूरे देश को था, महाराष्ट्र को ही नहीं। और एक अच्छा निर्णय, मुझे ऐसा लगता है कि डेमोक्रेसी में हम लोग कहते हैं कि जिसके पास मेजॉरिटी है तो वही सही होता है। तो आज देखो, उद्धव जी को छोड़कर जब 55 में से 41 एमएलए जब निकल जाते हैं तो उनके पास 14 एमएलए बचे हुए थे। बिल्कुल सीधी बात है, क्योंकि उनके हाथ से पूरी पार्टी निकल गई थी, उनका वहां कुछ बचा भी नहीं था। और उसके बाद तो उन्होंने रिजाइन भी कर दिया था। अब रिजाइन देने के बाद में वो कहेंगे कि भाई हमारी सरकार हम ही लीगल है, तो मुझे लगता है ये बहुत गलत बात थी।
पर गिरीश महाजन जी, नैतिकता पे आपकी ये बात कहाँ बैठती है? अगर आप देखें जो भी सुप्रीम कोर्ट ने कहा है, चलिए उन्होंने ये तो माना है कि एकनाथ शिंदे की जो सरकार है वही अभी रहेगी, पर महाजन जी उन्होंने साफ ये भी बोला है कि जो भी हुआ ये सरकार बनाने में आप उसको इंटरप्रेट कर सकते हैं कि सब इलीगल है। और उन्होंने ये भी कहा है कि अगर एक उद्धव ठाकरे जी रेजिग्नेशन ना देते तो फिर कोर्ट उनको रीइंस्टेट कर सकती थी।
हाँ, लेकिन उनको भी पता चल गया था कि हमारे साथ अभी लोग नहीं रहे। 11-12 एमएलए उनके साथ बचे थे, 40 लोग 41 विधायक जो थे उनको छोड़ चुके थे। उसके बाद में उन्हें भी था कि भाई अभी मैं क्या करूं, कि इतना इंसल्ट उनका होता था कि उनके साथ 10 लोग भी नहीं बचे हुए थे। तो उसके बावजूद क्या करते थे वो? और कोई नेता के खिलाफ कोई पार्टी
महाजन जी, बात कितने लोग बचे ये नहीं थे, बात बहुत सारे और आंकड़े इसमें आ रहे हैं। जो गवर्नर का रोल, उस पे सवाल उठाए जा रहे हैं, स्पीकर का रोल, उस पे सवाल उठाए जा रहे हैं। और साफ साफ ये भी कहा है कि जो ऑफिशियल व्हिप, लीगल व्हिप है, जो लीगल व्हिप है वो अभी सुनील प्रभु जी हैं, जो ठाकरे फैक्शन के हैं।
नहीं, अभी तो लीगल, अभी उन्होंने बताया कि उस वक्त वही थे, अभी वही है। लेकिन अभी तो नेता गट के अभी शिंदे साहब है, अभी वो दूसरा भी चुन सकते हैं। अभी दूसरा भी मीटिंग लेकर वो भी चेंज कर सकते हैं या नया व्हिप दे सकते हैं। ये भी कोर्ट ने तो अभी साबित कर दिया कि इनकी सरकार है, अभी नेता ये है। तो मुझे ऐसे लगता है कुछ भी हुआ तो आज का निर्णय ये बहुत महत्वपूर्ण है। और उसके बाद इन्होंने अगर रिजाइन नहीं
All right, we seem to have lost Girish Mahajan midway. But you know what is interesting is that both factions here, be it the Shiv Sena, Uddhav Thackeray and the Eknath Shinde faction, will claim victory, will claim what has happened in court as their victory. The Shinde faction will say it's relief to their government, while the Thackeray faction will clearly say that the whip, Sunil Prabhu, is the recognized whip, while the Shinde faction appointed whip has been called as illegal. So both factions will come out claiming victory from what has happened in Supreme Court today, viewers. But it's very, very interesting because what really went down in Maharashtra was unprecedented. It's a complex judgment. Ultimately, it says that Eknath Shinde remains as Chief Minister of Maharashtra. His government stays. However, with whatever the observations were of this judgment, clearly seem to suggest that the process of it was illegal. More so that the official recognized whip is Mr. Sunil Prabhu of the Uddhav faction and not of the Bharat Gogavle of the Eknath Shinde faction. Listen in to all reactions coming in.
सर, आपकी सरकार से खतरा फिलहाल तौर पे लगता है कि हट गया है। आप संतुष्ट हैं जो फैसला आया है?
हम संतुष्ट है। हमारे सरकार को पहले भी खतरा नहीं था, आगे भी खतरा नहीं होगा, क्योंकि हमने जो भी प्रोसीजर किया है वो कॉन्स्टिट्यूशन को फॉलो करके किया है और माननीय सर्वोच्च न्यायालय ने वो एक्सेप्ट किया हुआ है। और जो भी माननीय सर्वोच्च न्यायालय का जो निर्णय है उसका हम स्वागत करते हैं।
स्वागत कर रहे हैं, लेकिन गवर्नर को लेकर काफी सवाल उठाए हैं, जिस तरीके से प्रोसीजरल फ्लॉज के बारे में उठाया गया है। को लगता है कि ये सब चीजें आपके फेवर में नहीं जाएंगी आगे चलकर? नहीं, अब गवर्नर ने जो डिसीजन लिया तो गवर्नर का इंडिविजुअल डिसीजन है, वो कॉन्स्टिट्यूशन के हिसाब से किया है, प्रोसीजर फॉलो करके लिया है। और उस दिन उस वक्त जो एटमॉस्फेयर था, वो जो सिचुएशन थी उस हिसाब से लिया है। फिर भी उनकी जो टिप्पणी है उसका भी उसके बारे में हम लोग सोचेंगे और उसके बारे में गवर्नर के जो लॉयर है उसका रिप्लाई करेंगे। कोर्ट ने कहा कि हम रिलीफ दे देते अगर उद्धव ठाकरे रिजाइन नहीं करते। सबसे बड़ी गलती है उनकी लाइफ की। हमारा पहला सबमिशन वही था, हमारे सीनियर लॉयर erstwhile जी का यही सबमिशन था कि माननीय उद्धव ठाकरे जी ने जो रिजाइन किया है उसी वजह से ये केस डिफरेंट है। उन्होंने एक आखिरी सवाल, मॉरल ग्राउंड पे इस्तीफा दे देना चाहिए, मॉरल ग्राउंड पे इस्तीफा देना चाहिए, मॉरल ग्राउंड पे इस्तीफा दे देना चाहिए। नहीं, क्या मॉरल ग्राउंड पे सरकार को इस्तीफा दे देना चाहिए? नहीं, क्यों इस्तीफा देना चाहिए? कॉन्स्टिट्यूशन को फॉलो किया हुआ है और हमारी जो सरकार है वो लोगों ने जो वोटिंग किया है उस हिसाब से सरकार बनी है। लोगों ने शिवसेना भाजपा के नाते सबको वोटिंग जो किया है उस हिसाब से लोगों का मैंडेट है और लोगों को चाहिए कि शिवसेना भाजपा का सरकार होना चाहिए। तो ये थे राहुल शिवाले।